Hello everyone. Today we have a topic called Section 79 of the Indian Penal Code. Uh, as per Section 79 of the Indian Penal Code, act done by a person justified or by mistake of fact believe himself to be justified by law. It is the marginal note of Section 79, and the main provision says nothing is an offense which is done by a person who is or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. Now, you must see that Section 76 and Section 79 both are approximately similar. The only one term is differentiated, that is justified by law. In Section 76, the term bound by law is used, whereas under Section 79, the term justified by law has been used. And therefore, it is read as nothing is an offense which is done by a person who is, by reason of mistake of fact and not by reason of mistake of law, believes himself to be justified by law in doing it. So, what does it mean? We have two parts of Section 79, that nothing is an offense which is done by a person who is justified by law in doing it. This is the point number one, that nothing is an offense which is done by a person who is justified by law in doing it. If the person is justified by law by doing in doing it, then he can be exempted from the criminal liability. And the point number two, that nothing is an offense who by reason of mistake of fact and not by reason of mistake of law. Again, we have already studied that if there is mistake of fact and it was not a mistake of law, mistake of law has no excuse, whereas mistake of fact is excusable. But it was done in good faith. So mistake should be a bona fide mistake. It should be a reasonable mistake. That means proper care and caution has been taken before coming on the conclusion. And he believes himself to be the justified by law. Now the question now you must go through the scope of Section 79. Actually, basically Section 79 is complementary to Section 76 of the Indian Penal Code. Section 76 should have been numbered or placed just after Section 76 and numbered as Section 77. But Lord Macaulay numbered it as Section 79. But more or less, Section 76 and Section 79 both are similar. The only difference is justified by law and the bound by law. It exempts from the criminal liability to those who are justified by law in doing it. Let us take an example that a person did committing the offense of murder, and it was seen by A, and therefore, as a reasonable man, as a responsible citizen, he wanted to prevent the offense of murder, and thereby he seizes Z, he apprehended Z, or he arrested Z so that he may not commit the offense of murder. But later on, it was found that the Z was acting in self defense. So, even the apprehension of Z, even the arresting of Z by A cannot be termed as crime, cannot be termed as illegal, because he was acting and which is justified by law in doing it. The A's act is justified by law, and therefore he cannot be criminally liable, and therefore he can be exempted from the criminal liability. Now, come to very important aspect of justified by law. There is a term called justified by law. Then what we call justified by law? Is there any difference between the justified by law and bound by law? In case of justified by law, there is an option to do or not to do. The person is having option either to do or not to do. But in case of bound by law, the person is having an option to do. He has no other option but to do. But in case of justified by law, the person is having two options, either to do or not to do. Justification means the person can do or not do, and thereby based off his judgment he decided to do, and therefore while deciding to do he is justified by law in doing it. As we have given an example that he had committed an offense of arrest, an offense of wrongful confinement, all but later on it was proved that he was acting in self defense. Still it shall not amount to an offense of wrongful confinement because he was acting, he was justified by law while doing it. We have a very important judgment on this point, that is Chiranji versus State, that was decided in the year 1952 by the Supreme Court of India. In this case, what happened? The father killed his son, considering him a violent tiger. He killed his son under insane delusion, and ultimately he was acquitted from the criminal liability, and it was held that he was justified by law while killing his son, since it was a mistake of fact and it was in good faith and not under mistake of law, and therefore he was having a bona fide belief that there is a violent tiger who is going to kill him, and thereby he killed. But it was ultimately developed and ultimately proved that it was his son, and therefore he was acquitted from the criminal liability. Now come to another important judgment on this point, that is Raj Kapoor versus Lakshman, that was decided in the year 1980 by the Supreme Court of India. You might have knowing a well-known film, that is Satyam Shivam Sundaram. It is a very famous film. In this case, what happened? It was sent to the censor board. The film was sent to the censor board for the certification, and the issue before the censor board was whether to award U certificate or A certificate. Since name showing that it is a U movie, it is a U certification movie, but it was not so, and therefore after releasing of the film, there was very hue and cry with respect to the certificate. Now, you must understand that what we call U certificate, what we call A certificate, and what we call UA certificate. Here, U certificate is issued as universal, that anyone can see the movie, is starting from the child to the old man, everyone can see the movie. A certificate means that only adults, that means 18 plus, will be allowed to see movie. They shall only be allowed to see movie, to watch movie, and the person who are below the age of 18 years, the children are not allowed to watch the movie in the cinema hall. Similarly, there is another certification under Cinematography Act, that is UA. Under UA certificate, what happens? The children who are above the age of 12 years, they are required to accompany with their parents, or the parent will accompany with the child, so that they may make them understand that actually what is going on in the movie. So what happened in this case? The censor board issued a U certificate to the movie, and when the film was published, and the producer of the film, he was prosecuted under section 292 of the Indian Penal Code. The producer, he was now prosecuted for the circulating obscene material in the public, and it was an allegation to the producer that title is misleading to the public, and they argued that the film is obscene, the film is lascivious, and it is tending to deprave the public morality, and thereby it is increasing or spreading the indecency in the public. Now what happened? The magistrate issued a notice, and the magistrate issued a notice for the prohibition of the exhibition of the film. Now they went to the High Court. The High Court dismissed the petition and held that the censor board could have been given a certificate. The High Court dismissed petition and held that the censor board could have been given a certificate. Then there was no objection, and rejected their contention that they are justified under section 79 to display the film because they got certificate under section 5A of the Cinematography Act 1957. Now, aggrieved by the decision of the High Court, since the High Court rejected their argument that they are justified under Section 79 to exhibit the film, and the producer was deprived by the judgment of the High Court, and now matter went before the Supreme Court. And what the Supreme Court of India held, that even if it is obscene, even if it is lascivious, even if it is indecency, but it is justified under section 79, and if it is justified under section 79, then it is exempted from the criminal liability under section 292 of the Indian Penal Code, and therefore there is no offense under section, there is no offense is made out under section 292 of the Indian Penal Code. So sanctioning a film with U certificate justified its exhibition. Once the censor board issued a U certificate, now the producer is justifying while exhibiting the film in the public, and therefore he can be exempted from the criminal liability. If the censor board don't want to display it in the public, then it must have issued a certificate or EUA certificate, but it was not issued, and therefore in the absence of certification, it may not constitute an offense under section 292 of the Indian Penal Code, and therefore ultimately the film was exhibited with U certificate. Come to another important section of Indian Penal Code, that is section 77 of the Indian Penal Code, that deals with act of a judge when acting judicially. So now the question is, when a person, when an individual is acting, and if there is mistake of fact and not mistake of law, then he can be exempted from the criminal liability under section 76 and section 79 of the Indian Penal Code. Under section 76, there is bound by law, and under section 79, there is justified by law. But if a judge is acting judicially and if he did mistake, then whether he can be exempted from the criminal liability or not, that is given under section 77 of the Indian Penal Code, and that says nothing is an offense which is done by a judge when acting judicially. So if a judge is acting judicially when he is applying his judicial mind, and if anything wrong has been done on the part of the judge, then he shall be exempted from the criminal liability. So it says nothing is an offense which is done by a judge when acting judicially in exercise of any power given by law. In good faith, he believes that the power is given by the law. So if the power is given by the law, since he believes in good faith, and if he believing that in bad faith that the power is given by law, then he cannot be exempted from the criminal liability. So you must go through section 52 of the Indian Penal Code, that what we call the good faith, that proper care and caution, proper application of mind has been taken place, and there is proper care and caution has been taken, and thereby the judge is coming on some certain conclusion. So in exercise of power, the power is given by the law, since he believes wrongly that the power is given by the law, and thereby in good faith he believes that the power is given by law, and he acted judicially, but he reached on the wrong conclusion. So it shall not be an offense by virtue of section 77 of the Indian Penal Code, and he can be exempted from the criminal liability. Now, what is the rationale behind section 77 and section 78? Since section 77 is the protection to the judges, it gives protection to the judges, that so that the judges may pass a fearless judgment. If judge is acting under fear, then he cannot deliver justice, he cannot give a judgment. So therefore, section 77 is the protection to the judges. It is providing a legal protection to the judges so that he may act judicially. And section 78 it deals with those who carry out orders against the criminal process. In case of criminal justice administration, if for example the police is executing order of the court, or any officer is executing the order of the court, then if while executing the order of the court, in pursuance of the order of the court, if he did something wrong, then he can be exempted from the criminal liability, provided he acted in good faith. If he had not acted in good faith, then he cannot be exempted from the criminal liability, even though he was executing the order of the court. For example, if the judge issued a warrant to arrest Z, but while executing the warrant, um, the police officer arrested Y under mistake of fact, or he believes that the judge has issued or mentioned a wrong name and he arrested Y. In such a situation, the person would be exempted from the criminal liability because he acted in pursuance of order of the court and in good faith. So, for acting freely and fearlessly, section 77 come forward so that judge may feel protected and they may pass a fearless order, and it is very much crucial for the independence of judiciary or independence administration of justice. If the judges are acting under fear, then they cannot deliver justice and they cannot deliver judgment. If suppose section 77 is not there, then every single judge would be prosecuted. The judges would be prosecuted that they have passed a wrong judgment, and thereby they can be prosecuted. But section 77 come forward and it protect to the judges. So, in whether it is a civil liability or the criminal liability, in case of civil liability, we have Judicial Officers Protection Act 1950. If a judge is passing a wrong judgment, then he can be protected under Judicial Officers Protection Act 1950. And if there is any criminal liability, then we have Section 77 of the Indian Penal Code, that the judge believes himself that the power is given by law and thereby he passed the judgment, then he can be protected under section 77 of the Indian Penal Code. And we have section 193 of the Indian Penal Code, that is punishment for giving false evidence, that is perjury. If any person giving false evidence before the court of law, then he can be punished under section 193 for the offense of perjury. Similarly, we have section 228 of the Indian Penal Code, where the judicial officer is given power. If any person is creating hurdle in the process of justice, then he can be punished by the judicial officer. Similarly, we have a constitutional power, that is contempt of court, and even lower judiciary is also given power, that is contempt of court act. So these kinds of power has been given to the judges so that they can be exempted from the criminal liability. For application of section 77, the person should be a judge. For claiming an exemption under section 77, the person should be a judge. Now the question is, who can be called as judge? Whether every individual can be termed as judge and he can claim protection under section 77, or every person can claim that he is acting under judicial authority under section 78 of the Indian Penal Code? No. There is definition of judge has been given under section 19 of 19 of the Indian Penal Code, that person must be authorized by law to give judgment. If the person is not authorized by law to give judgment, then he cannot be a judge. So there are various requirements that when a person can be termed as judge. So as per section 19 of the Indian Penal Code, that a person or body of person. What does it mean? That even a person can be judge, that means individual, or body of person can also be termed as judge. For example, a bench, two judges bench, three judges bench, five judges bench, or even seven judges, nine judges, 13 judges bench can be termed as a judge who is in judicial proceeding. So the person was acting in a judicial proceeding. That judicial proceeding may either be criminal proceeding or a civil proceeding, and he is empowered by law in this behalf. It doesn't mean that every person is acting in judicial proceedings shall be a judge. Rather, he shall be empowered by law to act in this behalf. For example, if the person is not empowered, if a person of a small causes court is trying a case of murder, then he is not empowered by law in this behalf, and therefore he is not acting judicially. So he must be empowered by law in this behalf. Is capable of giving judgment. The person should be capable of giving judgment which is definitive in character. What does it mean? The judgment delivered by the judge should be definitive in character. What does it mean? It is full and final judgment, and there is no other interpretation. There is no other thing left in this particular matter, or which may become definitive if not appealed against. Suppose judgment given by the High Court, judgment delivered by the Supreme Court, that is definitive in character. And if suppose judgment is given by the lower court, the district court, if it is definitive if it is not appealed. If the matter is went into appeal, then again a judgment delivered by the High Court would be a definitive judgment. If there is no appeal from the district court, then definitely it would become a definitive judgment. So which may become definitive if not appealed against, or become definitive on confirmation by the other court. If it is the judgment given by a lower court, if it is confirmed by the higher court, then it becomes a definitive judgment. So the person was acting judicially in accordance with the power given by the law, believes in good faith that such power is given by the law. As per section 77, the person who was acting judicially and he was acting in accordance with the power given by the law, and he believes in good faith. The good faith is very important term, that it was not a malified faith. If it was a malified faith, then again he cannot be exempted from the criminal liability, and there would not be any protection from under section 77 and section 78 of the Indian Penal Code. So he believes in good faith that the such power is given by law, then in such a situation he can be exempted from the criminal liability. uh, thank you very much. Hope you might have understood that what we call section 78, section 77 and section 79 of the Indian Penal Code.